Can I settle my public transport accident case in Queensland without going to court? It is a common misconception that making a public transport injury claim in Queensland will end in a trial before a judge in court. The reality is that very few matters proceed to trial. Our systems and laws are set up to try and keep these matters out of court, allowing the injured party to settle their matter and have access to compensation without the delay and cost of a trial. A point comes in every public transport accident claim when the procedural matters are taken care of, injuries are stable, and the evidence is gathered. At some point, the parties will explore whether there is an opportunity to settle the matter before involving the courts. In fact, the law requires the parties to participate in settlement negotiations before any court documents can be filed to initiate the court process. These are called pre-court procedures. Approximately 80% of public transport injury claims are settled before court documents are filed. Who decides whether I settle my public transport accident case in Queensland? The decision to settle your public transport accident claim or not is yours. That can be incredibly empowering and overwhelming at the same time. While this is a moment that you have waited for and anticipated, it's not uncommon to have a flood of questions and fears when faced with the reality that this claim could soon be over. Understanding what your options are, what the process involves, and what role your lawyer will play at this time will be the key in making the decision that is best for you. Every claimant has a choice to settle the claim or go to trial and let a judge decide. A settlement is where you and the other party come to an agreement, and the terms and any payments are agreed by both of you. The agreement is final, and neither party can change their minds later on. This will give you a certain outcome. You know exactly what you have agreed to and when payment is due. If you go to trial, you are leaving the outcome to the decision of a judge. Sometimes a reasonable settlement cannot be reached, and going to trial is warranted. Each side will present their evidence before the judge, and the judge will decide if the other party is at fault or not, and how much compensation, if any, you should be awarded. Which judge hears your case, their decision, and how long they take to make a decision is completely out of your control. The compensation laws in Queensland are written in a way so that there are procedures in place to encourage people and create an opportunity to settle out of court. This reduces legal costs and keeps the courts from overflowing with these matters. Approximately 98% of claims are settled between the parties before a trial is commenced. There will come a point in your public transport accident claim where you are faced with a decision to accept an offer from the insurer or to prepare to go to trial. Keep in mind that the matter may still settle before a trial commences. It is your lawyer's job to give you advice about what they recommend you do. Ultimately, however, the decision is yours. Only you can make the actual decision as to what to do. We recommend listening to your lawyer's advice and asking any questions that you may have, so you feel fully informed when you give the lawyer your instructions about whether you want to settle or not.